Please be seated. Thank you. Deputy Commissioner Blanche, would you just give us your full name for the record? Please?
Colin John Blanche.
And do you wish to swear an oath or affirm?
Oath, please. I, Colin John Blanche, swear by Almighty God that the evidence I shall give to this Commission shall be the truth, the whole truth, and nothing but the truth.
Thank you. Please be seated. Ms. Winner.
May it please the Commission, Quinlan for Deputy Commissioner Blanche.
Thank you.
Deputy Commissioner, I think hopefully in front of you will be document WIT 00800010001, which is your witness statement.
Correct.
Do you see that in front of you there?
I do.
And are you able to identify that that is 16 pages long with 65 paragraphs? And he also has a hard copy in front of him, which will become reason why in a moment.
Yes, it is.
And you signed that on the 9th of June 2021? And there's a index and also a table attached to that witness statement, is that right?
Yes, there is.
Are there any corrections that you would like to make to that witness statement?
Yes, there is.
Can I take you to paragraph 28, please? I understand there's 3 corrections that you'd like to make to that paragraph.
There is. The second sentence, the movement of funds should be is supported rather than are. And then further on in that sentence, it says it's a misspelling of frequent. It says fluent instead. And then the sentence that starts, this provides national and international established criminal networks the ability to commingle rather than to ability.
Thank you. And can I take you to paragraph 46, please? And I understand there's 2 corrections, or 3 corrections you'd like to make to that paragraph.
Yes, there are. The first one is the misspelling of links without the E. The second sentence should read, hawala is potentially an illegal form of international remittance.
I'll remove the word traditional and remove the words form and of.
Yes.
And add the word potentially.
Yes.
After is. Thank you. And lastly, paragraph 49B.
Yes, that should remove the words lack of and just be the opaqueness of casino holding accounts.
Thank you, Deputy Commissioner. Can I ask, is this witness statement true to the best of your knowledge, information and belief?
Yes, it is.
I would like to tender that statement, please, but I'd also like to seek a non-publication order in relation to paragraphs 15 and 16, where it refers to the MOU between WA Police Force and Crown, and also discussions in relation to a review of the MOU. And I understand there aren't any objections to that.
Thank you. The witness statement of Colin John Blanche, dated the 9th of June 2021, bearing the identifier number WIT.0008.0001.0001, with the corrections that have been outlined in that exchange with Council, and noting a non-publication order in relation to paragraphs 15 and 16 of the statement. The statement is admitted into evidence as an exhibit. Thank you. Ms. Cale.
Thank you, Commissioner. Deputy Commissioner Blanche, if you could go to paragraph 18 of your statement, please. That's at page 0004. You identify there 3 main types of casino banning measures. Can I just clarify in relation to table 1, annexed to your statement at page 0017? Need to wait for the screen if you just want to use your hard copy.
That's all right,
There we
it's
go.
there.
There's in the second last row, there is a reference to statistics for trespass offences. You see that there?
I do.
I ask you, is that statistic there reflecting the number of offences relating back to paragraph 18 for entering the casino when a person is the subject of one of these casino banning notices?
Yes.
Thank you. Paragraphs 21 to 25 of your witness statement, that's at pages 0005 to 0006, you explain that you attended a meeting of the GWC on the 16th of February 2021, consequent upon Mr Ord seeking advice from the Commissioner for Police as explained in paragraph 21 about how to improve reporting of suspicious transactions in the context of the AML/CTF Act. My question is this: does WAPOL continue to engage with GWC in respect of that topic?
Western Australia Police ceased engaging with GWC due to this Royal Commission, and the intention is to re-engage post when decisions are made about what the forward landscape will be.
Thank you. Now, at page 0007, at paragraph 29, you're explaining there about the way in, or the ways in which criminals typically launder money through casinos. Can I just ask you about little b, paragraph little b, and the second sentence of that subparagraph? Can you just explain for me in a little more detail how a customer has the ability to use their patron account ID number to reduce the visibility of the customer value of funds held and transaction details?
A third party can deposit cash into a patron ID number, so someone who wants to provide money to be laundered in a case of a laundering case does not necessarily need to be the player, but they can provide cash into a patron ID, so you don't know the source of those funds or the intention of them.
Thank you. Now, if we drop down to the next paragraph, paragraph 30 on the same page, you explain in this paragraph in terms that junkets are attractive to organised crime groups for the purposes of money laundering. The Commissioners may benefit from a slightly more detailed explanation from you verbally about why that is so.
In relation to junket tours, it's more about how organised crime works. And so organised crime require two things. One is to move money from one place to another without it being noticed, or also return the money to themselves with a different source of funding, so a more legitimate source of funding. So with a junket tour, because the casinos in Australia have a third party or a broker, if you will, who is the junket operator, the money is pooled together. So the identities and the source of funding, when it's pulled together, the detail isn't apparent to law enforcement. So I'm talking in the perspective of a law enforcement officer. It's not apparent whose money it is, if it's been moved from one place to another, and does it return? Does it get let out into the community? What is the intention of those people in a junket? How are they going to use that money? Is it all for gambling? Is it for other purposes? All those reasons that we would normally ask a casino in an ordinary gambling environment aren't readily available when it's a junket, because the contract is between the casino and the junket operator. So there is that wall of vagueness, if you will, for law enforcement to the actual gamblers themselves about the origins of the money, the use of the money, the transport of the money, and whether it is in fact criminal process.
Now, if you turn to page 0009, this is paragraph 39 of your statement. You refer here to WA Police's involvement in checking applicants to conduct junkets and how that involvement ceased in April 2000. In the second sentence of the paragraph, when you say, you've just pointed out that the involvement ceased in 2000, you say there was at the time no mandate for WA Police involvement in this process. Can I just ask what you mean there by no mandate?
I was advised, this was records that I sought from our organisation, that there was nothing in legislation or policy at the time, either in WA Police or as part of the Casino Control Act or the policy at the time, that required a check to be done through WA Police to assist them with information around junket operations.
Now, the next paragraph, paragraph 40, you go on to say that, in substance, that if junkets recommenced in this jurisdiction, WA Police would seek to be involved in the probity checking of those people who are involved in junket operations. Can I ask you this? What do you see that the probity checking on the part of WA Police would involve in practical terms?
The ability for WA Police to check intelligence both nationally and globally in 2000 was limited. In 2021 and ongoing, our ability to obtain intelligence and or evidence or information about individuals nominated either on a junket operation or sources of funds is greatly improved than what it was. So that probity would involve identities, networks involved, sources of money, countries of origin, associates here in Australia. We would be able to acquire an extensive check on who those junket operators and participants were.
And do you mean by reference to intelligence holdings to which WA Police presently has access?
Yeah, correct.
Yes. Do you envisage that it would involve GWC having to collect any information that it does not presently collect?
I think that's subject to a forward discussion, particularly involving GWC, AUSTRAC, WA Police, National Law Enforcement, to sit down and work out exactly what we would like collected to make sure that we had the right amount of information to make the best intelligence check.
Is there anything that occurs to you presently without having had that conversation that you say, well, I see that as something that it would be useful to obtain from GWC by way of information?
When you say from GWC, I'm assuming we're talking about information they collect from the casino.
In their capacity as regulator,
yes. One thing we would certainly want is the number of times that they had attended here, the associates they've attended with, whether the junket operator, if it was a recommencing of junket operations, was a local person in WA, or details about that individual and where they came into. How they come into Australia, I should say, how long they've been here, and probably their pattern of play and or attendance at casinos around the country.
And what about Crown Perth? Do you think that if WA Police were to become involved in probity checking of junket operations in the future, there would be any information that you would envisage would be useful to obtain from Crown Perth or Perth Casino, the operator, that you don't presently collect?
Well, I think that's the value of a regulator, is that the regulator has far greater access to normal business operations of a casino that we would seek. That police force are more interested in people committing an offence, so we have to be satisfied to get to that level, and we would rely on a regulator to advise us that the level of information that they had obtained started to meet a threshold of being reasonably suspected of committing a crime. Other than the casino coming direct to us, I don't think our role is to probe a casino of all of their holdings.
So if I understand you, in summary, you're saying if there is additional information to be provided on the casino side, if you will, you would see it preferable for that to come through GWC to WA Police?
Yes.
Understood. Now, at paragraph 43, at page 0010, you refer to WAPOL's online access to AUSTRAC's systems, and you explain that provides WA Police with real-time, you call it, access to AUSTRAC information. Can you just explain to the Commissioners, please, how that real-time access is of particular assistance to WA Police?
Much of Australia's organised crime is sourced from overseas, or people arriving from overseas to conduct business, and I'm talking about high-level organised crime. And one of the benefits they rely on is slow-moving government processes, policing processes, so they operate very quickly. They come in, they do their business and they leave. So having access to an alerting function through our financial regulator from the Commonwealth, we can detect those alerts early and act quickly. And the important thing for us is to detect individuals who might be here doing that organised crime before they go, because that's where the problem starts when they've left.
Now, at paragraph 46, you refer to the hawala system being used by criminal networks in the absence of operations. I wonder if you could just explain in a little more detail how the hawala system works.
If I could go back to my earlier corrections, that should say money transfer without money movement. Apologies, I just read that.
You're referring to the fourth line.
Yes.
The words in parentheses should read money transfer without money movement.
Correct.
Rather than money transfer with money movement.
Yes. So could you repeat the question?
Yes, I just wanted you to explain to the commissioners in a little more detail how the hawala system works.
Hawala is a very traditional way of moving money. Was used well before banks in trade across the globe, and it's a trust-based system. It's when you have individuals in various countries who have a need for money, so they offset the account. If someone needs money here and someone needs money in another country, they just do the transaction in location, so the transfer doesn't actually occur. The movement of the money doesn't have to physically occur across boundaries, or even a bank transfer doesn't need to occur. So the important thing for hawala, when organised crime look at that as a plan or a strategy to use to go under the radar of regulators, they look for others who have a need for money in another jurisdiction, so they will offset it. And the way they can do that is if a drug trafficker is here in Western Australia and earns lots of money from the sale of those drugs, they have an extraordinary amount of cash. There might be a legitimate need for cash in a business here, or someone needs to invest their money, so they might have their money overseas in the country of origin of that drug trafficking network. Through usually a third broker, an alternative remittance broker, they will work out that there is almost a perfectly matching offset between the two. So that cash that was earned from drug trafficking here goes into the legitimate investment, and the money that they would have used for that investment, rather than transferring it from that foreign country, goes to the source drug trafficker in that country of origin. So it's an exceptional way to move money without being caught by a regulator.
How would you see it operating in a practical sense in a casino like Perth Casino?
There could be a person who has travelled from overseas into Western Australia who wants to gamble large amounts of money because they're a gambler and a legitimate gamble, and then they're a wealthy person, and they need access to Australian dollars to gamble quickly. Their country of origin may not allow large transfers out of their country. They may have restrictions on the amount of money that they can send out, flight of capital problems. So if you have the right broker, they can actually arrange for drug trafficking money to be given to that person, wittingly or unwittingly, to gamble with, as long as they hand their money in their country of origin over to the person that organised it, and then it finds its way back to the drug trafficker. So many of the people often involved in hawala are legitimate business people.
So when you say in the first paragraph of 46, in the absence of formal junket operations, criminal entities and links to established criminal networks will use hawala, are you contemplating there that individual high rollers would come and gamble using that system potentially?
The advice that I gave the GWC at that meeting in February was exactly that. Don't get too focused on junket operations. Junket operations are essentially the broker taking on some of that risk for the casino. However, the individual high rollers are still in existence. So if there are no junket operators, the high rollers still will want to spend their money here. And again, to avoid some of the regulations, and it might not be money laundering from drug trafficking, it might be restrictions in their own country moving large amounts of money. The best way to bypass that, to get the money in Australia, is hawala.
And is there any risk you perceive for hawala being used in respect to domestic patrons of casinos? including Perth Casino?
Hawala is still the way for them to get the money out. So when the domestic drug trafficker earns all the money and it goes to the legitimate gambler, the domestic drug trafficker still has to contact overseas and receive the money from the legitimate gambler overseas. So that is the domestic side moving their money. Hawala is an offset, so it's actually in and out at the same time. They call it a mirror transfer as well.
And do you see the use of hawala as a potential risk in Western Australia, particularly with relevance to the Perth Casino, or an actual risk?
Hawala is an overall money laundering risk to Western Australia. Includes the casino, but not. I wouldn't. It's not exclusive. It's not exclusive to the casino. Hawala is a significant organised crime technique for money laundering in WA, and it's not just the casino.
Thank you. Now, at paragraph 51, page 0013, you're starting to talk there about cryptocurrency, and you refer to the prospect that Perth Casino will move to a cashless transaction base at some time in the near future. Can I ask you, what is the likely impact of that move on the risk of money laundering occurring at or through the Perth Casino?
If I could just make another correction.
Yes.
This will, the second sentence, this will increase the visibility of money, of value moving in and out of the casino, not cash.
Yes. Thank you.
Apologies if you could just ask that question again.
So what I'm interested to understand is, with that move to a cashless transaction base, what you consider to be the likely impact of that on the risk of money laundering occurring at or through Perth Casino?
Cash is one of the greatest forms of value that is very difficult to track the origin of. So as we have seen, or I have seen in law enforcement over many years, suitcases of cash going into banks, casinos, alternative remittance operators, being transported in trucks, the origin is very difficult to determine. When, in a money laundering sense, it gets placed into a system, whether that is banks, whether that is in the form of cryptocurrency, there is a trail, not always a fantastic trail to identify, but at least it provides an avenue of inquiry for investigations to commence. So electronic forms of value are a better starting point for law enforcement if there is suspected to be money laundering than cash alone.
And just so that I understand it, if I can take you back to the question before last where we were talking about hawala, if Perth Casino were to move to an exclusively cashless transaction base, how would it specifically affect the risk of hawala, the use of hawala at the Perth Casino?
It will remove the risk of hawala at the casino, but not in the state of WA. So the hawala can operate, the person can receive large amounts of cash, they still have to place it into a system at some point to get it into casino credits.
Right, now just finally at paragraph 58, which is at page 0015, this is where you begin talking about additional information that would assist in addressing key strategic risks, is how you've identified it. And in the first sentence of paragraph 58, talk about additional reporting requirements by casinos to AUSTRAC. Can I just ask you what specifically you have in mind there as regards additional reporting requirements? Well,
the current reporting requirements, which is an international funds transfer, being one, which is of any amount coming in, a threshold transaction report, which is the $10,000 or over, and a suspicious matter report, which is the assessment of the individual managing the transaction to determine whether or not something is suspicious about it. What is not often clear to AUSTRAC and to law enforcement is, again, the tracing of the money and the entry and exit points of the money, and whether it's passed between different persons, what it's been used on, how it's spent, the gambling records as to whether or not it's a legitimate gambling process. Now, that can be sometimes contained into suspect matter reports, But as algorithms and technology gets better, the reliance on people reduces, and algorithms should be able to detect strange patterns of money. And I think the casinos in Australia have come a long way in understanding suspicious movements of money. It's about that very clear reporting on algorithm identification of suspicious transactions. And that's where I think law enforcement and regulators, both Commonwealth and state, and casinos themselves, could work together on a very clear set of algorithms. And by algorithms, I mean detections of money movements and the way it's moved between individuals and or entry and exit. There could be a very clear sequence provided that they must report on any of those triggers being hit.
So if I understand that, just to make sure I understand it, instead of it being left predominantly in the hands of the reporting entity to make sometimes impressionistic or subjective decision about whether a transaction is suspicious or not, what you're advocating for is an objective set of quite detailed criteria that are agreed by, against which reporting entities like casinos must report.
If I can say, the SMR process has always been plagued by lack of money laundering knowledge. Money laundering can be quite complicated, it can be well hidden by organised crime, and it may not be apparent to someone who's relatively junior sitting in a cash box receiving cash. It might not give that clear appearance of money laundering. So absolutely I would support using technology to identify suspicious transaction and mandate the requirement of the reporting on each and every occasion on an agreed basis.
How do you see that giving rise to the benefits that you identify in 59 through to 61? Is that simply because you're more likely to raise suspicious matter reports when previously transactions weren't being reported, and it just increases the intelligence holdings for both AUSTRAC and the law enforcement agencies who share that information?
And it creates resilience in the system, because I believe organised crime are quite mature, particularly some of the countries in Asia. The organised crime elements in there have been at this for a long, long time. So they will study our laws, they will study our regulations, and they will find ways through it. So the harder you make it, the more resilient the system becomes, because they will look elsewhere. They take the path of least resistance.
Nothing further, Commissioners. Thank you.
Thank you, Ms. Gale. Are there any applications to cross-examine? Mr.
Thank
Garrett.
you, Commissioner. Deputy Commissioner Blanche, my name is Garrett and I appear for the Crown Companies. I just have a few questions for you. First of all, Operator, can we bring up, and just on the personal screens, please, document CRW.709.149.5257. Thank you. Now, I'll just get you to confirm, Deputy Commissioner, that that is the Memorandum of Understanding that you referred to in your statement.
We can just see the last page, perhaps.
So you move forward, please, to page 5265. Are you looking for the signature?
Sorry, signature.
5265, please.
That's it, yes.
Thank you. And then can you go to page 5261, please? Deputy Commissioner, I'm just being very vague about discussing the contents of it, obviously because it's sensitive, but if you look at clause 7 on page there, are you aware of the frequency and volume within with which Crown provides the sort of information referred to in clause 7 there?
I can't give you a number, but I know WA Police and Crown have a very good relationship that results in significant amounts of information exchange or coming to us, coming to WA Police.
Thank you. And have you found that Crown has been very cooperative in relation to the provision of that information?
Yes.
Thank you. Now, can we bring up document CRW701.005.8192 and just on the personal screens, please. Now, this is a letter from what was back then Burswood to the Commissioner of Police in 2009. I'll just direct your attention to the last paragraph, third line down, where there's reference to a request for consideration being given to allocating additional police resources to the Kensington branch for a permanent WA police presence to be located at Burswood during peak times. First of all, have you seen this letter before? Are you familiar, or are you familiar with the request that was made back then?
No, I'm not.
Thank you. And then if we can just please go forward to page 8199. So this is really just the conclusion, but in particular the second paragraph down restates the request for a permanent WA police presence at Burswood during peak times, and in particular the first bullet point identifies obviously creating a visible deterrent in relation to various kinds of behaviour, including illegal behaviour, and then the second last bullet point identifies keeping police fully informed of individuals frequently, activities occurring on the site which may in turn be beneficial to various police units. Now, I'll just take you very briefly to the response. It's CRW dot, and just on the personal screens again please, 707.005.0538. This was the response received back in June of that year. If we can just go forward to page 0546. Thank you. Now, you'll see it was sent by the then Deputy Commissioner, and the second paragraph records the fact that based on essentially resourcing considerations and constraints that the WA Police was not in a position to accommodate that proposal. Now, and in no way am I being critical of the police here. What I'm interested in understanding is, would you consider it beneficial to have a permanent police presence at the casino during peak times?
As an entertainment precinct, which is what I would consider the casino complex, I understand the police and casino engagement, particularly around disorderly behaviour, is what it should be. It's working well. We regularly do send patrols around there, but I believe a permanent presence is not in the interests at this time of WA Police or the community.
Thank you. I have no further questions, Commissioners.
Mr. Garris, are there any other applications? Mr. Evans?
Could I? Thank you, Commissioners. Just briefly. Deputy Commissioner, my name is Evans. I act for the Gaming and Wagering Commission. If I could just ask a couple of questions to clarify some aspects of your evidence. Now, I understand from your statement that much of your evidence in relation to matters prior to 2018 is obviously based on inquiry, as you weren't based in this jurisdiction at that time. So your evidence in relation to the history of the relationship between the GWC, the casino and the police prior to that time is about information which has been supplied to you. Is that correct?
Correct.
Is it your understanding from your inquiries that prior to about 2000 there was in fact a police position funded through the Gaming and Wagering Commission to support effectively inquiries into activities at the casino? Are you aware of that?
I'm not aware of that, no.
All right. Since that time, or at any time, has your inquiries indicated that police have dedicated specific resources to investigation into activities at the casino?
So in the time frame,
Well, at any time prior to your appointment and certainly since your appointment.
yes, they have.
And are those resources criminal intelligence resources or are they investigative resources?
That would be a combination of intelligence,
Yeah.
investigations, and more recently, financial investigations.
And that is because I think in your report you indicate that serious and organised crime, financial crimes, and also most recently money laundering have taken an active interest in casino activities. Is that right?
Sorry, could you...
So you indicate in paragraph 8 that you have a serious and organised crime and financial crimes division which investigates serious organised and financial crimes. Those parts of your organisation which are effectively interested in activities at the casino?
That's one of the roles of those functions, is to investigate money laundering, including casinos, but also any institution that manages money.
And you also have a money laundering squad, as I understand it.
Yes, we do.
That, I understand, the money laundering squad very recently reached out to GWC, I think from memory, and or the casino in order to establish a liaison with GWC. Are you aware of that?
I am aware of a couple of officers that reached out to GWC recently, yes,
Yes.
prior to, I understand, or shortly before the meeting that I had.
That's correct. Now, to your understanding, is that the first occasion such liaison had been established?
I don't know the answer to that.
Thank you. Just to understand, you have a good understanding of the role of casinos and junkets generally in what I might call the financial crimes landscape in Australia through your ACIC involvement, I understand it?
I have a good understanding of how organised crime works, not necessarily how casinos work.
But of their role in relation to money laundering?
Yes,
And that, in fact, is the source of your information, the evidence which you give at paragraphs 26 and following, really, isn't it?
yes.
Now, ACIC published a number of publications, some of them during your tenure, including publications in relation to financial crime in Australia and in relation to, serious financial crime in Australia and, pick up the other one, organised crime in Australia, both in 2017. Were you involved in those publications?
The Austrac publications?
No, those are the ACIC publications.
Oh, sorry, yes, yes.
Right. I was interested to see that junkets are not mentioned at all in either of those publications, and casinos are only mentioned once and in only one of them. Is that your understanding?
I don't have them before me, but
So just to understand the scale of the issue which is being addressed, do you regard casinos and junket operations as being a principal risk or merely one of many risks which are the subject of police activity?
one of many risks.
Okay. Now, one of the matters which you were discussing when Ms Cahill was asking you some questions was, as I understood it, really the role of a regulator in exchanging what might broadly be described as intelligence information. That is not operational or investigative materials. Because you obtain at the moment operational and investigative materials under your MOU with Crown, is that right?
I think it's for the police, in my view, it's for the police to determine whether or not it ends up being information, intelligence or evidence. That determination isn't made. It's what I was saying earlier was that a regulator can obtain information from the casino and based on their skills and knowledge, we can then have a conversation about where that fits into the world of, is it evidence, is it intelligence that would help us do a further investigation, or is it just information that doesn't serve any purpose?
So the role that you're contemplating there is not that all of the information gathered by the regulator would be transmitted to you as a matter of course by way of broad intelligence gathering, but that there'll be some level of analysis considered on an intermediary level before the transmission of that information.
I don't believe WA Police has any business in looking into commercial organisations' whole of information holdings. If the casino want to come forward with information that they consider to be criminal, of course we would accept it. But we would rely on a regulator to have the full access to that information and to make assessments of that to then engage us if they reach the same conclusion.
So just to understand that in relation to the information requirements which were in place in relation to junket operators prior to about 2010, the regulator came into possession of certain information in relation to junket operators as a matter of routine. That is, the fact that they were visiting and their passport identifying information. Is that information which WA Police would seek as a matter of routine or only after a measure of analysis and consideration by the regulator?
Going forward, WA Police would, for a junket operation, given the risky nature of it potentially being money laundering, we would prefer to have the informations of the junket operations.
So your preference would be from an intelligence gathering perspective to obtain information in relation to each junket operator and each junket participant as a matter of routine.
It would be subject to a volume discussion. Again, I think this would require all parties together to set some boundaries, to have a clear memorandum of understanding across everyone, because we are looking for the high-risk events. If there are a large number of patrons and it's not something that we're terribly concerned with, we would have to land on whether or not we needed everything or just ones that posed a risk. It might be a value decision. If they're bringing in $20 million, I would say, yes, we'd want to see it. If it was sub 500,000, I probably would, depending on the volume, probably not of interest.
And by necessary extension, that would extend, would it not, to what is called in the casino the other aspect of international commission business, that is high roller players as individuals?
Absolutely.
Now, I think in your evidence in relation to the operation of hawala, you indicated that plainly foreign nationals, including individual foreign nationals who were engaged in high-value transactions at the casino, presented a hawala or mirror money transfer risk. Is that correct?
I talked about foreign nationals because hawala, whilst offsetting can occur within Australia, we are a federated country, so you can pass over borders without border checks. So hawala risk really applies where you're trying to conceal the movement of money over foreign borders.
Yes. The extension of that, which I think you partially addressed, is whether the same is true of what I call high-value domestic gamblers who might be involved in cash transactions or value shifting. Is that a logical extension of your proposition?
One of my earlier answers was about how organised crime need to use institutions like casinos, and the first one is moving money from one location to another. But the second part to that was returning the money back to them with the appearance of it being legitimate income. And so that second part relates to domestic high rollers.
Now, it's fair to say, isn't it, that these risks in relation to casinos are not new risks?
No, I think there's been reports on them since well before 2000.
Yeah, thank you. Did I take you to say that it is now the case that WA Police access to foreign intelligence information is now considerably better than it was in 2010?
Yes, it is.
And that would facilitate, obviously, the integration of intelligence which might be received from the casino or from the regulator into WA Police's broader intelligence holdings. Is that correct?
Yes.
Now, paragraph 40 of your statement, you indicated that were junket operations, and I use junket in the broader sense there to include actually individual foreign commission business, to be recommenced, WA Police would seek to be involved in probity checking of those involved in such operations, and I think that includes down to the individual participants, is that correct?
Yes.
With veto rights over the approval process. Now, we had some evidence from Mr. Lee a couple of days ago about cooperation between the casino and the police in relation to what I call the active conduct of intelligence gathering and possibly operational activities where persons of interest might actually be facilitated to undertake activities at the casino in order to monitor those activities. Is that a factor in relation to the probity checking you're contemplating in paragraph 40?
Can you ask that question again?
Would you grant somebody probity in order to see who they were and what they were doing under paragraph 40?
That is an operational decision, but it may be the case.
Maybe the case, thank you. In table 1, which was attached to your statement, you identify crime statistics at the casino, and I take it that is specifically the casino precinct that's being referred to in table 1. Is that an identified statistical entity in itself from a police reporting perspective?
It would be a download from our information management system, which would just include the words Crown Casino. So it could be anywhere in that precinct.
There's not an identified category of what I might call financial crimes other than fraud and forgery in that list. Is it the case that these statistics don't capture AML, CTF or other financial crimes, or are they subsumed in some other category?
This refers to the location being at the Crown Casino. Money laundering offences, when
Have no
investigated at a higher level, occur in lots of places over some time, and we usually arrest a person in a location that's not the casino.
Thank you, I understand. No further questions. Thank you, Commissioners.
Thank you. Any other applications? Commissioner Jenkins?
Could I just clarify, Deputy Commissioner, are you saying that in respect of those statistics, they are people who've been arrested at Burswood?
Well, the offences occurred there, and they've probably been arrested shortly after, given the nature of those offences.
Thank you. Can I ask, in relation to junkets or international business, we've heard evidence about the fact that GWC and the department were comforted by the fact that Border Force and or the Department of Immigration would carry out checks on people coming in to Australia. And I wanted to find out whether WAPOL was involved in any sense in that process. That is, do the Commonwealth authorities ever contact the local Western Australian Police Force about people who might have been here previously and what intelligence that the local police would have before granting visas?
I'm not aware of any further granting of a visa.
There's also been discussion about international visitors coming in on private jets otherwise than through the main international terminal, and thereby avoiding customs inspections or customs inspections to the same rigour that the ordinary international traveller would face. Does the Western Australian Police have any input into the level of such inspections or
No, we
how
don't.
they occur or anything of that nature?
No, we don't.
You were asked by Mr Evans about whether you knew about the secondment of a police officer to the regulator quite some years ago. You said you didn't, but what I'd like to know is whether is that a model which the Western Australian Police currently employ? That is, do they have any police officers seconded to regulators
No, we don't.
So would it be something which the Western Australian Police would consider now, or is it not something that is any longer in the repertoire, so to speak?
I don't think that would be as useful as a regular intelligence briefing by police officers who had experience in money laundering. One of the challenges of law enforcement officers, either retired or current, who go and work in a place like that, is you lose currency very quickly. Organised crime change their methods rapidly, and you have to be at the forefront of money laundering to understand how they're operating. So putting someone in somewhere it doesn't necessarily solve that problem.
Thank you. Those were the questions that I had.
Thank you. Deputy Commissioner, I've just got one question for you, and it relates to junkets and high rollers. I think you said that when you met the GWC in February this year, you cautioned them against becoming too focused on junkets, and that individual high rollers also presented a risk that ought to be looked at.
Yes.
I'm sure you're aware that later in February of this year, the Gaming and Wagering Commission made a direction banning junkets.
Yes.
But they went a little further and included premium player activity and privileged player activity, which, as I understand it, is where the casino has an arrangement with a foreign national, a foreign passport holder, for either to pay them a commission on their gaming turnover or to provide accommodation, etc. It would say there's an arrangement in relation to the individual. Does that assuage the concerns that caused you to make that comment to the GWC, or is this issue of individual high rollers broader than that?
No, it's not broader than that, except to say the comment that I made was more in that organised, and this is from the perspective of organised crime rather than high rollers. Organised crime go out of their way to replicate legitimate behaviour. That is their role. They replicate legitimate behaviour, so it's harder to find. So my comment was more intended to say, if you have the right regulations in place, the right technology detecting strange movements of high rollers, meaning if the money came in with a high roller and didn't go back with that person, or they legitimately lost it, instead it stayed here, or vice versa, you've got to find the organised crime in the high roller because the money is there. So my intent was to not stop high rollers. I never suggested that. What I actually said was the organised crime will be hidden in the high rollers, if that makes sense.
Yes. And on a similar theme, you drew a distinction between the hawala mechanism, which is no value movement, but through offsetting the same impact or effect on the one hand, and more if I could put it, the more traditional use by organised crime, or another use by organised crime of money laundering, which does move cash. And you said there were two aspects to that. One is the movement, in this case into Australia, of cash in a way that avoids detection. That's the one side. And the other is getting the money back in what is cloaked in the aura of legitimacy. Now, in answer to a question from Mr. Evans, you spoke about the domestic high rollers, and you said where they come into play, it's in the second limb, which is getting the money back under the cloak of legitimacy. Did I understand you correctly in that?
Correct. So that is in the context of casino winnings being used to disguise illicit income from drug trafficking sales, as an example. You can go to the casino and play safe and win at the casino. So you get the money back as casino winnings. again, that can be captured in algorithms of the casino to see that, and they do that quite well.
Yes, and what I'm asking is whether or not that is the form of money movement, money laundering. Could that also play a part in the offsetting arrangements in hawala? For example, you did say that, I think you said in answer at the end of that answer to Mr. Evans that the money would then go back to the drug dealer. So could that be a part of the offsetting arrangement as well?
If I understand that question, organised crime are agnostic to their money laundering methodologies, and that's one thing I have learned in my career of investigating money laundering. They will use hawala, offsetting, which is offsetting, structuring, trade-based money laundering, bulk cash movements, cryptocurrency, and they will mix them up. And the way they will decide which ones to use is the one that we're not looking at. So the reason why I'm not giving you a direct answer as to whether or not they could do it with hawala and at the end on the domestic side is they absolutely will, but it depending on which one generates the greatest scrutiny from law enforcement. So they use them all. So the techniques that we apply in WA Police is really about being agnostic to the money laundering technique, but following the money itself.
Thank you. Anything arising?
No, thank you, Commissioner.
Ms. Quinter, do you wish to re-examine?
No, thank you.
I'm just wondering, there were, I think, a couple of additional corrections made during the course of exam. Perhaps the easiest way to deal with this is if you could send in a list of the corrections and we can just include it in some form as an addition to the statement. All right, thank you. Deputy Commissioner, thank you very much for your evidence. That has been of great assistance to us in building up our understanding of this issue, this part of the issue. Thank you very much indeed. And you are now free to go with our gratitude. Thank you.
Thank you.
And we will adjourn till 10 a.m. tomorrow.
All rise.